What is a contract? A contract is an agreement between legally competent parties in which one party agrees to do something, or not do something, in return for consideration, payment, from another party. The following are examples of contracts in real estate: listing agreement, sales agreement, deed, mortgage, land contract, installment contract, contract for deed lease, assignment, option, exchange. What is a novation? A novation is a three-party agreement whereby one party is released from a contract, and another party is substituted. A novation is often required in conjunction with assignment of debt contracts. Another use of the word novation is to mean substitution of one contract for another.
Like, comment, subscribe.
What is closing or settlement? Closing, also called settlement, is the act of transferring ownership of a property from seller to buyer in accordance with a sales contract. The time when a closing takes place. What is a meeting of the minds? A meeting of minds is an agreement to the exact terms of a contract by all parties involved. It occurs upon acceptance of the offer, including its terms and conditions. What is a duty to disclose? The duty to disclose is the legal requirement of a seller, broker, or agent to tell a prospective buyer or other interested party about a negative condition. What is parol evidence? Parol evidence is oral evidence, as opposed to that contained in documents, written. The parol evidence rule states that when parties put their agreement in writing, all previous oral agreements merge into the written agreement. The written agreement cannot be contradicted by oral testimony, unless there was a mistake or fraud. The term parol, like parole in the context of prison, is derived from the French word for to speak. To remember its meaning, it might be helpful to associate it with parole, someone's word or oath, and parley, oral discussion or conference. What is a binder? A binder is an agreement, accompanied by a deposit, for the purchase of real estate. The binder shows good faith on the part of the purchaser. In some states, a binder is customarily prepared to guide and precede an agreement. Within a few days, 5 to 10, depending on the state, an attorney will draft a contract of sale. For example, Abel gives Baker a binder on a house for sale in New Jersey. Abel then contacts his attorney to prepare an agreement of sale. What is the closing date or settlement date? The closing or settlement date is the date on which the seller delivers the deed, and the buyer pays for the property. The sales contract generally states this date, at which time the parties will meet and settle all accounts necessary to transfer the title to the property. Closings are commonly held at a title company, attorney's office, bank, or mortgage company. What are the parties to a contract called? What are some abbreviations used in contracts are? What are the parties to a contract called? What are some abbreviations used in contracts are? What is escrow? Escrow or an escrow contract is an agreement between two or more parties providing that certain instruments or property be placed with a third party for safekeeping pending the fulfillment or performance of a specified act or condition. The most common use of escrow in real estate transactions is for the earnest money deposit, which the broker must place in a separate checking account until the contract is either fulfilled or expires. If the contract is fulfilled and the sale closes, the seller receives the deposit. If the conditions of the contract are not met, the deposit is refunded to the prospective buyer, provided the contract doesn't state otherwise. What is meant by latent defects? Latent defects are flaws that are hidden but are likely to surface later. Latent defects are an exception to the principle of caveat emptor. What is an assignment? Assignment is the method by which a right or contract is transferred from one person to another. To assign is to transfer one's property rights or contract rights to another. Types of contracts commonly assigned are leases, mortgages, and deeds of trust. What is meant by caveat emptor? Caveat emptor is Latin for let the buyer beware. It describes a general doctrine in which a buyer must examine the goods or property and buy at his own risk, except for latent defects. In recent years the doctrine has been eroded, especially by the disclosure requirements about property conditions, introduced in many states. Often a property is offered as is, with no express or implied guarantee of quality or condition. When entering such transaction, caveat emptor is a worthy admonition. What is amendment to a contract? An amendment is a change, correction, or extension of an agreement that does not change the basic thrust of the agreement. What elements are necessary for a valid contractor? Every contract must have at least these elements: Offer and acceptance, meeting of the minds. Subject matter. Competent parties. Consideration, mutual obligation to give something. Legal purpose. Can an offer, or counteroffer, be rescinded, that is, withdrawn? An offer, counteroffer, can be withdrawn any time before it is accepted. Once it is accepted, it is a binding contract. What is an express contract? An express contract is a written agreement that includes the elements needed for a valid contract and specific terms of the contract. It is contrasted with an implied, unwritten contract. What is a legally competent party? To be legally competent to buy or sell real estate, a party must be mentally capable. Of legal age, 18 in most states. Duress may void a contract. A party who has been told, your signature or your brains on this contract has been put under duress to sign. What is consideration in a contract? What is good consideration? Valuable consideration? To be valid, a contract must include consideration, which is anything of value given to induce entering into a contract. It may be money, personal services, a product, or intangibles. Good consideration is founded on generosity, affection, or moral obligation. Valuable consideration is something of value, such as money, property, or time. What is a unilateral contract? A unilateral contract is an obligation given by one party contingent on the performance of another party, but without obligating the second party to perform. What is meant by an executed contract? To execute a contract is to sign it, so an executed contract is one that is signed by all the principals. Generally, when a buyer and seller sign a sales contract, they execute it. Executory means that it has not been executed. Something is left to be done. What is an addendum to a contract? An addendum, plural, addenda, is something that is added as an attachment. Another word used for this is rider. Some commonly added addenda in real estate purchase agreements are for financing terms and property inspection requirements. What is a rider to a contract? A rider is the same thing as an addendum, it is an addition that rides along with the contract. The term rider is more commonly used in connection with insurance policies, which often include riders to insure specific valuable property, such as jewelry, silver, antiques, or art objects, against loss. Is an amendment to a contract the same as an addendum? No. Usually an addendum is prepared with the original contract, while an amendment is a later change. Can a seller who is under a contract of sale prepare an amendment, for example, to delay closing by a week? For an amendment to a contract to be binding, both parties must agree to it. What is an incompetent? In legal terms, someone who is incompetent is not legally capable of completing a contract. Minors and those who are mentally ill or senile are among those considered incapable or incompetent. What is a disclosure statement, and when is one required? A disclosure statement is a printed document that reveals specified information about something offered for sale. Sellers of particular kinds of real property and investments may be required by law to furnish such a statement to prospective buyers. What is an assignor? An assignee? An assignor is someone who assigns or transfers an agreement or contract to another. The assignee is the person who receives the transferred agreement or contract. What are contingencies or conditions in a sales contract? Contingencies or conditions are provisions in a sales contract that some or all of the terms of the contract must be met, or the sales need not to be completed.